We're here with Colorado's best attorney, Phil Harding. And Phil, I understand you've been getting a lot of phone calls lately about, people have questions if they're injured on someone else's property and really how to maximize their recovery.
Yeah, that's right.
Yeah.
It used to be called slip and fall cases. Now it's under a statute called the Premise Liability Act, and everyone calls it by its acronym PLA. And I want everyone to know that under the PLA, there are 3 different types of people that are on the property of another, and one of them makes sense. Trespasser, we all know what that is, right? So if there's a trespasser, let's say in your backyard, the only way that you can be found liable is if this trespasser gets hurt on a condition that you made. For example, if you had an open hole, and you dug a hole and they fell in that. So that's the only way that a trespasser can get some sort of recovery is by a danger created by the owner of the property.
That seems, actually still surprises me because they're still trespassing. They shouldn't be there where the hole is anyway.
Yeah, well, that's the PLA. Now, the next one is known as a licensee. And so a licensee, here's the best way to understand it. Let's say you're renting an apartment. When you're inside your own apartment, you're a licensee. If you're out on the common area, you're what's known as invitee. But let's talk about the standard of a licensee. A licensee, the landlord or the property owner is really only liable for a danger that they knew, that the owner actually knew about it. And then the last one is an invitee, and let's talk about that. It's if you're renting an apartment, it's the common area, or if you're in some store, you're considered an invitee. And the standard there is where the property owner either knew or should have known by this danger. So those are the 3 different individuals that are on the property of another, and if they're injured, what that standard is. Okay,
so who is going to pay for the medical bills when you're injured in a situation like this?
All right, because you want to use your health insurance. Now, the property owner may have something that's known as medical payments. I don't want you to touch it, don't want you to use it. I want you to use it to pay for deductibles and out-of-pockets, because generally med pay is very small. It's like $1,000. You want to use your health insurance, and here's why. So if anyone has health insurance, Medicaid or Medicare, they see these all the time. It's called explanation of benefits, and everyone refers to it as an EOB. And if you look on this particular one, this is a real EOB, and this is a surgery that was done at Swedish. And so the billed amount that went to the health insurance was $29,000. Your health insurance comes back and says, nah, normal and customary, we're going to reduce this by $20,000, and the amount that's covered by the plan is $8,500. Now, you might be saying, why are you showing me this? And I want to tell you why. Because there's this thing called the collateral source doctrine, and it says, if you are hurt on the property of the other, and you send the other side your medical bills, you only send them part of the medical bills. You send them the billed amount, not the paid amount. Because when you settle your case, you should get paid that full $29,000, not that $8,500. And if you sent your bills to the other side, their insurance or the property owner, they may come back and say, oh, that's great. I'm glad you got this reduction. I'm going to pay you this $8,500.
So they get to take advantage of your reduction, and they shouldn't get to take advantage because you've been the one paying the, for insurance and all this time, right?
That's right. The health insurance premiums, you've been paying for it years and years and years, and the other side hasn't been paying for that, and they're not going to pay you back for it. So let me just show you, if we can come in. So here's the EOB. Do you see that?
Yep.
This is the way you send it to the other side. You redact. You cover up everything. So you show the $29,000, and it's not like you're using liquid paper saying, I'm being deceptive. You say, you are not entitled to see this. So that's why you send to the other side. There it is. You only show them the $29,000. So when it comes to settling,
that's a big difference.
Huge difference. On that alone, there's $21,000 difference. So that's the biggest mistake that I hear. The other thing is, remember, the other side's insurance company does not pay for your medical bills as they come in. They may through the med pay, but again, don't want you to use that med pay, right? So the other side writes one check when they settle a case or once you take them to trial. So don't show them that. You only show them the $29,000.
Okay, and really quickly, when you do get paid back, do you have to then pay back your,
health
the medical
insurance?
bills? Yeah.
Right. Yeah. So if Medicaid, Medicare, or your health insurance paid back, that word is called subrogation. And so, yes, you may have to pay that back, but you can always negotiate that down. Talk to an attorney.
All right. Thank you so much, Bill. We
You're
appreciate
welcome.
it. And if you have a question for our legal expert, go to kwgn.com. Click on Colorado's Best. You're going to see Phil Harding's photo on there, and you're just going to click on his photo. And when you do that, you can send him your questions directly. He'll take the time to answer them each personally and confidentially. And to reach Harding & Associates directly, here's the number, 303-762-9500. Write that down, 303-762-9500. You can get a free consultation anytime, and you can find him online. His website is hlaw.org.